And on politics tonight, the feds sue the Chicago Police Department for stop and frisk. The lead plaintiff's attorney will join us. Stop and frisk. You know, according to the U.S. Supreme Court, the Constitution allows a police officer to stop and frisk a citizen when there is reasonable suspicion that the person committed or is going to commit a crime. Today, on behalf of 6 African-American men, a federal lawsuit was filed against the Chicago Police Department. The claim: police officers regularly violate the Constitution by stopping and frisking mostly black men who have not committed any crime at all. The specific defendants are the city, the police superintendent, Gary McCarthy, and 14 police officers. Tony Romanucci is the lead plaintiff attorney. He's a partner at Romanucci and Blandin in Chicago, and he's joining me tonight from the Tribune Tower. Good evening.
Bill, good evening to you too.
All right, 14 officers. Why aren't they being named at this point?
Well, we just haven't gotten into this stage yet where we know who these particular officers are. There are many unnamed officers. Once we get discovery, we can name them. But typically what you'll see is that our main target defendants are the ones that are named, and that's the city of Chicago, the police department, and the superintendent.
Give us a couple of examples of abuse of stop and frisks that will be brought up in this trial.
Well, very simply, Bill, we brought an excellent example to our press conference today. This was a gentleman who had installed his own security system just for his own protection at home, and one night he had placed a home delivery for food, and he was waiting on the street, on the sidewalk for the delivery when an unmarked police car came the wrong way down a one-way street. They both came out of their car, both ununiformed police officers came out of their car, stopped, frisked, emptied out this gentleman's pockets, asked him what he was doing. He told them what he was doing, waiting for food, and they still proceeded to take out the contents of his pockets out, throw him on the ground, and then once they did a name check on him to make sure he was clear, they let him go. And that's what we see. Most police officers in unconstitutional stop and frisks will stop suspicious-looking people, ones where they cannot articulate that either a crime has been committed or one will be committed, and hope that they find something, whether it's a weapon, drugs, or something on their license such as a warrant. That's what they'll look for. And the problem is, the way they did it, that's wrong, it's illegal, and it's unconstitutional.
Now I have to believe that claims like this have been going on for decades. Why is this case coming forth now?
Well, first of all, we do have to thank the ACLU for its research that they conducted last year. They found that Chicago is way off the charts when it comes to conducting Terry stops, or these stop and frisks. We had 250,000, according to their stats, conducted in a 4-month period, which is way above the rates that even New York City, which really pioneered the stop and frisk policing policy, thinking that it reduced crime rate. When in fact, I believe the statistics bear just the opposite, that stop and frisks either increase crime or that it doesn't change it at all. And I think we've got some good statistics to back that up.
All right, you've got statistics, but you're talking about specific instances. Will you have any kind of evidence to introduce outside of the testimony of police or of people who have been victimized?
Oh yes, we have video evidence. This one particular gentleman I just spoke of, his stop and frisk was recorded videographically, and we even we just recently talked to another person, and we saw the video of his stop and frisk. So we do have incidents of this beyond just he said and she said, which is what most of these cases are about. Now, because we have so many of these stop and frisks in Chicago, we're going to be able to move, and we hope to be able to move as a class against the city and get some sort of court-ordered intervention and supervision to stop this practice.
So a class action lawsuit you're hoping to put together. Is the claim
Correct.
here ultimately that officers are using racial profiling in deciding who to stop?
Absolutely. Again, if you look at Chicago's police own statistics, we're not talking about stats that we don't know of. or ones that may have been skewed to fit certain, periods of time. But if we look at their own statistics, African American males get stopped at a rate that is almost 4 or 5 times, if not higher, than any other racial segment in the city of Chicago. In some neighborhoods, it's up to 10 times. So generally, it's 4 to 5. In some neighborhoods, it's 10 times more than that of any other race.
Tony, when the ACLU report came out just a few weeks ago, I remember Superintendent McCarthy, he was emphatic. He just said racial profiling is not allowed among the force in Chicago. Let me tell you about what I heard. I heard an interview on the radio today with a longtime New York City police officer. He's got a book out. I'm going to get it. Sounds fascinating. He said he became quite skilled in picking out people on the street who had a look, a walk, a manner. He doesn't know specifically, but it was all based on his experience and intuition. But it suggested that they were about to commit a crime. It was kind of uncanny. He would follow them sometimes for hours, and in many cases, if not most, indeed they did pull off a crime and were arrested in due course. He said race had nothing to do with this intuitive sense that basically a beat cop develops.
Well, we would need more police officers like that, because the way you described it, he actually policed correctly. If he had a hunch, he followed it until the moment that he was supposed to, and hopefully he stopped the crime. However, indiscriminate racial stopping of people because they're either driving while black or standing on a street corner or waiting at a bus stop, that kind of stop and frisk behavior is not allowed and it's unconstitutional. And I repeat, we all want good policing. Everybody wants that. But we need it to be consistent with the bounds that the U.S. Supreme Court set in the Terry versus Ohio case. The way you described that gentleman, his hunch is working in New York, that's good policing.
You concede suspicion of criminal intent can be very hard to determine?
It can be very hard, and there is a fine line. And that's where you have to be a good police officer. And you know where that comes from, Bill? Training.
Well,
training.
Are you discounting that the city is not making a reasonable effort in trying to train their officers in proper procedure?
That is correct. Again, there's empirical evidence, and I think it was straight from the Chicago Police Department that they have not trained their police officers in Terry stops since 2011. Just like anything else, if you don't practice your trade, you will not know what to do. Terry is a very important part of policing, and it's necessary that they be trained not only on an annual basis, but routinely.
What do you expect, very briefly, is going to be the timetable here? Will this go to trial perhaps in a year or longer from now?
Well, it's hard to say. This case was filed as a federal court case. Federal court cases tend to move a little swifter than they do in the county system. But having said that, you could anticipate a trial anywhere from 12 to 24 months from now.
Tony Romanucci, thank you very much.
Bill, thank you. Have a great evening. Appreciate it.